Hey everyone, Rob Ryder. Tuesday, the 11th day of September, 2012. Oaths and their consequences, and what can you do with it? And we've talked about these things before. The invalid oaths should make it known that they vacated offices, and that there are certain jurisdictions in various political divisions. Different districts or divisions have different jurisdictions, and your domicile determines the jurisdiction. And the other one was how the law was written to cause defects and to cure the defect. And I knew that to be true because I had read it in Blackstone before, but I didn't really comprehend it until just recently. And I'm going to try to show you some things that why they may have been written the way they were, and why I'm going to be going down the particular path I am based on what I've read. And thank you for everybody who contributed. I did get enough to take care of my landlord. Thank you, Jesus. Thank you, Lord. Very, very helpful. I don't know what I'm going to do next month, so if you can help, please do. You can send it to this address, Elector Retluski, Robert Allen, care of His Embassy Sanctuary, 14 Mile Road Northeast, 10955, the Elemental Republic of Oakfield, 49341-8664-55. Again, people wonder about this 11-digit zip code. Obviously, the first five are your regular zip. Every 100 block, every block has got a number for these four digits here. 8664 defines a block of 100 numbers. 100 lots, and 55 is the last two of my house number. So I'm in lot 55, and I just identified the territory where I'm at. And I said it's the Elemental Republic of Oakfield. And they will send mail there. Again, PayPal account's ashleyretluski@gmail.com. And that is the email, that is the PayPal account, right? So that's what you use as a PayPal account. Okay, so where do we go from here? What have I found that it just blowing my mind? First of all, let's go here. So this oath here, this first one, oath of public officers, is for somebody to take a civil office. And it says all offices, legislative, executive, and judicial, before entering upon the duties of their respective offices, shall take the prescribed and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office of, whatever his office is, according to the best of my ability. No other oath or affirmation or any religious test shall be required as a qualification for an office or public trust. Okay, excellent. Now, here's one that looks really close to that, right? This is an elected official, and this is a coroner. Now, I haven't gone to look at what Washington's Constitution says to take the oath, but this is pretty close to what the other one was, except, you put your name in, right? And I don't know about putting your name into things, right? Because this oath here doesn't have any place to put your name in. So if you put your name in this one in Michigan, you would not be taking the prescribed oath. If you said, "So help me God," you wouldn't be taking the prescribed oath. In the U.S. Constitution, Article 6, this is talks about the oath that the officers need to take. And you see the name is in brackets, and so help me God is in brackets. Again, I don't think that you add those in. But so real quick, yeah, this is an idea of an oath that you could look at in the state of Washington, and you could go to your state constitution and see if it says what the prescribed oath is, and if it isn't what this is, then this is not a civil oath. Yet it's still an oath. In Michigan, this is what the oath of office looks like at the township. you got the name in there. Do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Michigan. Well, again, I'm going to show you in here. It says nothing about the Constitution of the State of Michigan, right? That isn't how it's written. So again, this is not an oath for a civil office, right? The oaths that we see here are if you were going to take a civil office, this is the oath you would take. Either this one down here for by the U.S. Constitution, or in Michigan, this one up here. Yet, this is the one they take. So, that doesn't seem to be the right one. And, you know, I got like 25 oaths, and they all read the same, right? Here's another one. Board of Review. Got the guy's name in, so help me God. It's not a civil oath. Same here. Not a civil oath. It's not an oath for a civil office. So, technically, all the civil offices have been vacated. Yet, all these people have taken an oath. And they've taken it, you know, solemnly swearing to God. So help me God. Well, if it's not a civil oath, it's a good chance it's an ecclesiastic oath. Title 12, Banks and Banking, you know, has in here that they'll take an oath. So bankers take an oath. So, this is Title 12, subsection 73, oaths for bankers. So they take an oath. And apparently it looks something like this. General Instructions, Oath of Bank Director. By the National Banking Law at 12 U.S.C. 73 requires each elected or appointed director to take an oath that he or she will, yada, yada, yada. So, you know, pretty much anybody who's an officer, I think we're going to find is taking some kind of oath. But they're not taking civil oaths. And then this is the oath that he would take for a bank director. You know, I'm not going to read it all. If you stop the tape right now, you can sit there and read it. I'll count to 5 and then, you know, start again. So, okay, so good enough. People are taking oaths. What's it mean to us? Well, let's find out. This is a book out of Canon Law, Book 4, The Sanctifying Office of the Church, Other Acts of Divine Worship, Vows and Oaths, Chapter 2, Oaths. So, this is out of Canon Law, right? So, oaths are covered by Canon Law. Beautiful. A person who freely swears an oath to do something specifically obliged by the virtue of religion to fill that which he or she asserted by oath. Okay, so if you freely swear something on an oath to do something, and you don't do it, well then, you know, you just committed perjury. There's an oath that says you will do it. It's been filed. It's part of the record. A promissory oath is determined by the nature and condition of the act in which it's attached. An act which directly threatens harm to others or is prejudicial to public good or to the eternal salvation is in no way reinforced by the oath sworn to do the act. The obligation of the promissory oath ceases if it is remitted by the person in whose favor the oath was sworn. So I should have gone and looked up remitted, but it sounds to me like it's always in force unless you say it isn't. But, you know, what is the definition of remitted? Do we need to physically tell them we're not binding you to your oath? And if we don't say that, then they are? I think that's what's saying, that they're always bound by their oath. We don't really need to accept it. We just need to go point out when they're not following it. So So canon law says the ecclesiastics have jurisdiction over oaths. Now, a lot of people in the past that I had done a video quite some time ago about the powers of the Vicar General. Number of audios and emails and so forth on it. And, so some people had gone and talked to Vicar Generals. And, normally what they say when you go in the office is, well, we have jurisdiction over canon law or church law. Right? That's what they call it. Well, when they say canon law, where are you at? Well, canons of judicial conduct by the state for the state of Virginia. This is off the State of Virginia website. Canons of judicial conduct for the state of Virginia. Oh, guess what? The state of Virginia is an ecclesiastic society. It's under canon law. And that's why none of these oaths they've taken are civil oaths. They're all religious oaths to an ecclesiastic society. And, so great. Rob, what do you do with it? Well, I don't know what we're going to do with it yet. And I know what I'm going to try. So, this is under ecclesiastical courts in the newadvent.org website. It's a Catholic website. Very powerful stuff's being said. And so let's see what it says. These are just excerpts from quite a long thing about ecclesiastical courts, ecclesiastical jurisdiction I've talked about. I sent some emails out on it yesterday. All these things you can just search on New Advent. Ecclesiastical courts, jurisdiction, judge. Pick which one you want to go look at. But so these excerpts are, in instituting the church as a perfect society, distinct from the civil power and entirely independent of it, Christ gave her, the church, legislative, judicial, and executive power to be exercised over her members without any interference on the part of the civil society. So, if you're part of this society of the church, and you'll find out that isn't necessarily bad, but okay, let's just go with it. They're all part of an ecclesiastic society, and therefore they don't fall under civil law. That's why they're immune. That's really the only reason they're immune from us, is we're trying to go at them in civil law, and they're immune to it because they're ecclesiastics. They can only be tried in a church court. To make this clearer, the author, in addition to an example drawn from certain effects of matrimony, borrows from the ancient canonist the illustration of a contract entered into by lay persons and confirmed by oath. Okay, so really, that's what an oath is. Where's these township ones? It's a contract. They're solemnly swearing that I will support the Constitution of the United States and the Constitution of the State of Michigan, and that I will faithfully perform the duties of the supervisor in and for the Township of Oakfield. And the Township of Oakfield, in that particular manner, is the unincorporated federal district. Otherwise, it's called Oakfield Township when you drive down the road. So they're going to faithfully perform the duties of the supervisor in and for the Township of Oakfield, the County of Kent, and the State of Michigan, according to the best of my abilities, so help me God. It's an ecclesiastic oath. Right? So anybody who thinks they're holding a public office, you're holding an ecclesiastic office, and you may get a visit by the Vicar General, because they freely admit when you talk to them that they have jurisdiction over canon law. And this is right off of their website that I'm showing you now. So here, to the obligation of justice is added that of religion. And we easily recognize a twofold juridical element, bringing the matter in question, at least as far as the value of execution of the contract is concerned, within the ecclesiastical as well as civil domain. Well, we can't find any civil officers to take our complaints to. But because they've taken this ecclesiastic oath as an ecclesiastic, we can take it to the church. A private individual, for instance, could not hand down a decision, nor could he compel others to abide by it. In the case of a secular judge, his jurisdiction comes from the civil authority. Well, they haven't taken any civil oath. They have no civil authority. So they are a private individual. And they're trying to get you to confess as an ecclesiastic by making you a resident of the state of Michigan. That made you a minister. And so they're taking you to an ecclesiastic court. In this domain, the civil power has neither legislative nor judicial authority. Whatever, therefore, concerns the faith, divine worship, the sacraments, or ecclesiastic discipline is foreign to the civil order. And they call it civil order. That's interesting. Like it's some kind of order of, monks. But, okay, so civil power has nothing to do with ecclesiastics. Ecclesiastics can only be tried in their own courts, and that's why they appear to have sovereign immunity. Because we're trying to use a civil court to go after them. Likewise, not all persons are to be judged by secular courts. The church could not permit her clergy to be judged by laymen. It would be utterly unbecoming for persons of superior dignity to submit themselves to the inferiors for judgments. The clergy, therefore, were exempt from civil jurisdiction, and in the ancient rule was sanctioned by custom and confirmed by written laws. On this point, the church has always taken a firm stand. Concessions have been wrung from her only where the greatest evils were to be avoided. Okay, so the church really wants to have this jurisdiction over people that have taken oaths under canon law. All the laws of Virginia appear to be canon law. Thus, in Christian antiquity, a council of Aquileia condemned the bishop for demanding a civil trial, and the council of another one decreed that clerks who strive to bring their lawsuits or disputes before secular judges should be deprived of their clerical dignity and removed from their office. Innocent III reprehended the Archbishop of Pisa for maintaining that, at least in temporal matters, a cleric could renounce his right of exemption and appeal before a secular court. Such action, said Innocent, was unlawful, even when the conflicting parties agreed to submit the matter to a civil magistrate. They can never go before a civil magistrate. They must be taken to an ecclesiastic court. The ecclesiastic exemption was not a personal privilege. It belonged to the entire ecclesiastic body. It could not be renounced by individuals. You're going to take an oath and play in the game. You're going to follow our rules. The true and adequate explanation lies in the peculiar necessities of the age, the deficient administration of justice, and the undue power exerted by the rich and mighty. So this is from a different section. Again, this isn't reading straight out of the thing, but what they're talking about here is that the ecclesiastics, the church, has jurisdiction when there's a deficient administration of justice. Well, all the offices are vacated. There are no civil officers. They're all ecclesiastic. Two methods of judicial procedure are recognized in canon law. One ordinary, also called full and solemn. The other simple, extraordinary, and summary. In the ordinary procedure, all solemnities prescribed by the law are observed. These are described in the second book of Decretals, devoted entirely to the conduct of ecclesiastic courts. So they're going to tell you, this is where, if you want to know how it works, go read that book, right? If you want to know how the full-length court process works, it may be summarized as follows. The party intending to bring a suit must first send to the judge a written petition manifesting his intention and setting forth his claim. If the judge thinks the claim reasonable and therefore worthy of hearing, he issues a summons calling the accused before his court. In modern civil codes, a private citizen can oblige his fellow citizen to present himself before a judge for the examination of a case. So in modern civil codes, a private citizen can oblige his fellow citizen to present himself before the judge for the examination of the case. Well, that's really what they're doing to us now when we go to court, because when you look at their documents, they don't have the seal of justice on them. And since there's no seal of justice, they really didn't follow due process of law. Yet in civil law, they allow you to do that. Though found in the Roman law of the 12 tables, the canon law does not recognize in the private individual any such right, and holds to the latter procedure of Roman law that dated from Eulpane and Paulus and was afterwards confirmed by the laws of Justinian. According to this procedure, the summoning of accused applies power of jurisdiction and must therefore proceed from the judge himself. And this is all about getting a justice to take your complaint. The way they do it now, they just, they just act like they're going through the lawful process, but they're not going before a justice. So when you read a complaint or a summons procedure, it says it must be under the seal of a justice, and it isn't. But in step 2 here, proceed from the judge himself, well, it will be. So the party intending to bring a suit must first send to the judge a written petition manifesting his intention and sending forth his claim. Send him your claim. The judge will read it. If he thinks it requires action, then they'll get the summons from the judge. In later times, these principles have been retained and even partially increased to extend by our civil codes. So again, this is the church talking by our civil codes. They serve even yet to justify many special courts, e.g., Court of Aqueducts for commercial disputes. So they cover commercial disputes. Contract law. Because my understanding is there's a book of canon law that, I don't know if it's called positive law or not, but apparently it's supposed to be what the UCC came from. All right, so the UCC is canon law. The proceedings may continue even on days when the court would not otherwise sit. As far as possible, all postponements are avoided. The formal declaration of the judge that the hearing is closed is not necessary. And sentence may be pronounced without the usual solemn formalities. It must, however, be written, and parties have previously been cited by at least one summons. Okay, so, sorry, that my phone's ring. I'm in the middle of these things, so I lost my place here. So up here they're talking about that you send the summons to the judge. And then there's a couple different ways it can go, and one is a full-length court case, and the other is a summary proceeding. So this proceedings here may not be in the right place. I may have put this in the wrong place, this one at the top. But anyways, we're going to talk about summary proceedings. Because the sentence may be pronounced without the usual solemn formalities. It must, however, be written, and the parties must have previously been cited by at least one summons. Those things, however, which are demanded in all trials by the natural law or common usage of nations must not be omitted in the summary trial. The promise under oath to speak the truth is never dispensed with. So it must always be under oath. Summary proceedings are commonly entered upon for one or two reasons, either because the cases are of such nature as to demand prompt settlement, alimony or necessary support, marriage cases and other cases of ecclesiastics, elections and offices, and benefices. And because the cases are of minor importance, slight and easily remedial injuries compared to the civil lawsuit for trifling debts. So we're going to go there and for instance, I have a satisfaction of mortgage for a refinance that was put into the Register of Deeds office. And it's basically, I've explained this numerous times in the past, your mortgage deed of trust that you have is a security instrument. And it has two kinds of security on it. It has real property for security, and it has personal property for security. The real property is the house. The personal property is the res, the payments. So if you've ever refinanced your property, if you go look in your property file, you should find in there a satisfaction of mortgage. Because Bank 2 made sure Bank 1 put one in there. And what that's showing is that they have released their interest in the personal property. In the Uniform Residential Mortgage Satisfaction Act, it says, but once they do that, they are also supposed to send you a UCC3 termination statement for the personal property. And they don't do that. It says, so you're supposed to write them a letter and ask for it. Well, so I did. And they haven't replied yet. So this is and it was sent to the officers of the bank who have taken an oath to operate in good faith. And apparently they're not. So they've committed perjury, fraud, heresy, false witness. Pick your commandment, right? They've created, they have committed a sin, and they're in an ecclesiastic society. And for that, they have to pay a penance. So where it says lawsuits of trifling debts, we're not asking for money. We don't want money. We want justice. I want my securities back. Right? So if I send the Vicar General a copy of the satisfaction of mortgage and the letter that I have written to the bank saying I'm asking for the securities back, this termination statement, and it's taken more than 14 days, 30 days, pick your time, then you should be able to send to the Vicar General and say, look, I gave them a chance, they haven't responded. You know, I'm bringing a complaint. They're committing perjury. They've perjured against their oath. That's a sin, right? It isn't 18 U.S.C. anything. It's no, you committed perjury. If a attorney's bringing a case against you, and you look at that summons and it doesn't have the seal of a justice on it, well, he's bearing false witness. You would send that to the vicar. Here's my evidence. This is not under the seal of a justice. They are bearing false witness against me. Nobody's taken an oath. I can't get justice. There are no civil courts, so I go to so the church picks up the slack and deals with the justice. In all such cases, the judge is allowed to base his sentence on evidence somewhat less conclusive than would be called on cases of greater importance. Right? So all I need to do is send him a copy of the letter. Here's the discharge. Here's my asking for based on this, right? Put down a few facts and send it to them and say that it appears to me that they are in violation of their oath. That would be perjury. It appears to me that a fictitious plaintiff is bringing a claim against a living man. That would be false witness. Summary procedure is now frequently employed in criminal cases of clerics. Well, to me, they're all clerics. The canon law, however, by instruction of the Congregation of Bishops of Regulars, restricts its use to countries whose bishops have formally obtained the right to proceed according to said instruction originally granted by the bishops of France, or granted to the bishops of France. And in 1883, a congregation of propaganda extended its use to bishops of the United States of America. I haven't looked that up yet to see what that is, what that congregation is. It may be asked, finally, what influence has the Roman law exercised on the canonical procedures described above? It is certain, on the one hand, that the judicial procedure of the canon law was already quite elaborate in its form when, in the early 6th century, the Emperor Justinian published his Institutus Digest and Code. On the other hand, it was very evident that Roman law, and particularly that of Justinian, has exercised a very great influence upon canon law. It universally admitted as one of the subsidiary sources of the canon law, especially in court procedures. So if you want to know the court procedures, you need to read the Institutus Digest and Code of Emperor Justinian. That's where they're saying the law comes from. Forget the rest of the stuff they've done. If you want to know how it works in court, Emperor Justinian has got it down in his books. The point is, there isn't much for us to do in court. We send them a complaint, and we complain about the correct thing. They violated their oath. They're an ecclesiastic in an ecclesiastic society, and they violated their oath. And the church has exclusive jurisdiction over ecclesiastics. The canon law, however, was wisely perfected certain enactments of the Roman law. Thus, the right of provincial possession in the Roman law was amplified and highly developed by canon law, which gave additional legal protection in the case of actual possession obtained by injunction of the magistrate. Well, so if the magistrate in an ecclesiastic court finds for you, you get additional legal protection. Basically, they're going to go get your stuff for you. The interdict, it is well known, was granted by Roman law for immovable objects only. The canon law extended it to movable objects and even to abstract rights. So it used to be possession, it had to be something, the land, I'm standing on it, it's mine. Okay, good. But also it's movable objects like your securities, your negotiable instruments, your interest, your rights, your God-given rights. Moreover, whereas the Roman law only a strictly legal suit was open to a person despoiled of his goods, the canon law allowed him an additional plea in equity. In addition, in the Roman law, a suit lay only against the despoiler or the one who ordered or approved the act, whereas the canon law permits the entering of a suit against any third person found in possession of the plaintiff's goods, whatever such detention were in good faith, whether such intention was in good faith or not. So, okay, that was it. So, anyways, the judge, you're going to send a complaint to the judge, and the judge is going to be the one that issues the summons. And in that summons, he's going to ask for whatever it is he wants to ask for from the person that you're complaining about. And if you're talking about your property, he could issue a we command summons to bring forward the record. And then wherever they find it, they can go get it for you. As crazy as it sounds, right? That is what it appears to be, because very simply, the church says they have jurisdiction over oaths because they're canons, and the oaths these people have taken are not civil oaths, they are ecclesiastic oaths. So, I don't know exactly how I'm going to write my letter yet, but it's not going to be very long, and it won't take very much evidence. So I'll leave you with a couple other things, right? On any deed of trust that you have, the bank has never acknowledged the deed of trust. It's a contract. They're basing that on holding your property, yet they've never signed it. So you give them 14 days according to Michigan law because it's an executory device and they haven't executed it yet. It's like any other deed. They're the grantee. They need to acknowledge the deed, and they haven't done it. You give them 14 days. If they don't do it, now they're in breach of contract, and you just take it to the vicar. So you may be able to scare the shit out of these people and just say, look, either you send me my property back, sign the deed of trust, or return my securities and their gain, or I'm taking my complaint to the vicar general, because you're committing perjury of your ecclesiastic oath. And, I'm going to let God sort it out after that. So that's all I had to say.